Good morning and welcome to the 9 St John Street webinar on vulnerable witnesses and parties. First of all, you will see that you are going to be receiving presentations from 3 speakers today, and there's a reason for that. And it is because the breadth of the subjects that we are going to be presenting on is of such importance to all civil practitioners who participate in litigation of whatever complexion, that we thought it would be helpful to have a number of different perspectives from different areas of practice, and that would hopefully provide a more comprehensive introduction to the matters that we're going to be presenting. In terms of the speakers today, to my left we have Isabel. Isabel Baylis is in the final stages of completing her pupillage within Chambers. She's undertaken an employment pupillage, but prior to that, and importantly for today's purposes, before coming to the bar, she worked as a professional inclusivity and diversity officer. And I'll explain in a moment the presentation that Isabel is going to be delivering. To my right, we have Brian McCluggage. For those of you who are familiar with 9 St John Street or practice on the Northern Circuit generally, Brian requires no introduction. He is a premier practitioner in highly complex personal injury litigation and insurance-related litigation, and he is going to be speaking to us about pre-trial preparations in relation to vulnerable parties and witnesses. My name is Ed Morgan. I think you should have received a flyer from Chambers detailing our respective bio details, so that gives you an idea of who's going to be speaking to you. How we're going to undertake the presentation today, you will note straight away that there are no PowerPoint presentations or handouts distributed for you to follow during the course of the presentation. And there's a reason for that. And the reason is that because of the degree of breadth of the subject, we thought that it would be more beneficial for us to ensure that the materials were circulated after the presentation. And by that means, we can ensure that any areas of overlap are refined, and the ultimate pack that's sent out is, shall we say, more tailored to the nature of the presentation that we've actually given. And also it enables you to be perhaps more relaxed in receiving some of the material we're going to be talking about in terms of familiarization of subject matter and gauging how and by what means it will be relevant to your own work. So in the course of our presentation, we are going to hear first from Isabel, and Isabel is going to be introducing us to some of the core concepts. Some concepts you'll be familiar with for those of you who practice in the area of employment law. Others will be less familiar because, as we will see, the material draws heavily upon concepts, practices, procedures which are undertaken within the criminal jurisdiction or the family jurisdiction. And some of you, of course, may practice in that area whilst others do not. So I'll hand over to Isabel for our first presentation.
Morning, everybody. I won't go into what I'm going to cover today because I feel like Ed has presented a fair summary, and I will launch straight into why this topic is currently so important. So essentially, it is considered integral to the access to justice. Not going to launch into a law lecture about the rule of law, about article rights to a fair trial, but these are all considerations. And essentially, it boils down to the fact that the claimant would be considered to have a right to a fair trial. And if this is not possible without adjustments, adjustments will be considered. But importantly, the defendant also has a right to a fair trial. And where there's a balancing exercise, where it's felt that one side will be prejudiced by adjustments or could be prejudiced by adjustments, this will also be a consideration. And this should be a consideration for all of you when you're acting against a vulnerable witness as well as for a vulnerable witness. And it's clear that the priorities are shifting within the court system and that this is becoming of increasing importance. There's been a recent consultation through the Civil Justice Council, and there have been recent changes, very recent changes in 2021 to the CPR, which I'll come on to. It's also important bearing in mind case management, getting the best evidence for your party, getting the judge on side, because this will be a key consideration for the judge, and maintaining control of the case and its progress. And I understand that Ed and Brian will be covering tips on this in further detail. So moving on to definitions of vulnerable witnesses. The key definitions can be found in Practice Direction 1A, which is an amendment included in the 2021 Civil Procedural Rules, and the relevant section is the overriding objective. I'd recommend that everybody reads this section directly, although it will be printed out, the relevant parts on my handout. In terms of where it comes from in the Employment Tribunal's presidential guidance, there is guidance on vulnerable parties and witnesses in employment tribunal proceedings. What I'm going to do now is just give you a quick moment to think about what you think those definitions will encompass. It just might help to have a reflection first before seeing how it's codified in practice. Okay, so moving on to the Civil Procedural Rules Practice Direction 1A, a person should be considered as vulnerable when a factor which could be considered personal or situational, permanent or temporary, may adversely affect their participation in proceedings and in giving evidence. And as you can see, this is an extremely broad brush to the definition of a vulnerable witness, and it's not codified in any kind of law. That it can be broken down really into two categories: vulnerability because of a personal characteristic, and vulnerability because a situational characteristic. So personal characteristics we might expect, they could include things like disability and language barrier. Situational characteristics, the person might ordinarily not be considered vulnerable at all, but because of the subject matter of the case, they would in those particular circumstances be considered vulnerable. And so they could be, for example, that the subject matter to them is traumatic, such as if they've had PTSD from an accident, or if over a long period of time they allege that they have been persecuted in the workplace and they'll have to face that persecutor. Just one more important point to note on that: all of this is not dependent on the person, it's dependent on the outcome. So essentially, a judge and the parties should be looking at how this will affect proceedings. There's no guarantee that because someone is vulnerable, it should mean they need adjustments. There may be cases where the vulnerabilities won't require adjustments. So it's important to bear that in mind, that just because a person has a characteristic, it doesn't necessarily need to have an impact on the case. Helpfully, there's some guidance about considering these outcomes. So whether a factor may adversely affect the ability of a party or witness to participate in proceedings, the court should consider. And I'd recommend you read this, but it goes on for a list. For example, consider their ability to understand proceedings, consider their ability to express themselves, to put their evidence before the court, etc., etc. Now, these are important, both in terms of these are very useful rules to bear in mind when making the application, so tying the adjustments to how they're going to affect the ability. And they're also very important criteria to bear in mind if you feel like the adjustment is inappropriate and prejudices your case, because you can use these to point out how that adjustment won't actually help their ability in any of these matters. In terms of the Employment Tribunal's presidential guidance, this is less new, and perhaps as a consequence of that, it borrows a bit more from criminal justice provisions, which I'll come on to how they differ later. But essentially, it says the same thing, and it repeats the Civil Justice Council. As the Civil Justice Council recognises, vulnerability can be internalised or be a reaction to the litigation process itself. It says again, be generalized or situational, permanent or temporary. So again, key takeaway from that, very broad brush, very specific to the circumstances and the outcomes. So looking at the powers that the courts have, so we've defined vulnerable witnesses, but what can the courts actually do? In the civil procedural rules, the court, with the assistance of the parties, so you'd be expected to have a role in this, should try to identify vulnerable parties or witnesses at the earliest possible stage of proceedings and consider their participation. Moving on to the power, if the court decides that a party or witness's ability to participate fully and or give the best evidence is likely to be diminished by reason of vulnerability, the court may identify the nature of vulnerability in an order and may order the appropriate provisions to be made. And this is extremely important because it shows that the nature of these orders are entirely discretionary to the judge. And this is actually a key difference between vulnerability provisions in the civil, criminal arena, for example. Again, powers of the tribunal essentially the same and discretional, although, as I said before, they do borrow from the criminal arena, and it presents the sorts of adjustments you might find in the criminal procedure, although makes clear that these are discretionary. So it talks about screens, for example, participating remotely, and the use of an intermediary. An important point in the tribunal is that the tribunal may not direct an order that public funding must be available. And this is quite important because of the way tribunals work and the way costs are bared. Each party bears their own costs, in ordinary situations you'd never reclaim those back. So even if you won the case, you would be funding the adjustment. And this is actually an issue that I've come across in practice. I was representing a respondent. The respondent had closed the business. The respondent director had Alzheimer's and needed a litigation friend, but couldn't fund that. And it was actually an extremely difficult situation. And in the end, we eventually managed to find a family member who would do it. But it's clear that further guidance needs to be given on this and how adjustments are funded when one of the parties needs the adjustment but doesn't have money. Currently, there's no easy answer to that. In terms of where these powers come from, so I've mentioned before that the criminal courts actually have legislation in dealing with vulnerable witnesses. So there's the Youth Justice and Criminal Evidence Act 1999. Obviously, because this is codified in legislation, there's a lot less discretion in dealing with it, but also there's a lot more funding. From the family procedure rules, which was perhaps the next arena to develop rules on vulnerable witnesses, they also have directions. Now, both of these are important in using them as a guide, and you can present them when making your applications or opposing applications. But it's important to say the arenas are very different. And we know, as I've said before, that it's discretionary in the civil courts. If you don't like these provisions, you don't have to use them. Or if you feel like that they are good provisions, but they need to be adjusted to the case, you can tailor-make them. I'm going to talk a little bit about some case law of what's been happening both in the civil courts and the employment tribunal, because it's a useful way of seeing how these issues are currently being dealt with. So Brian Morrow and Shrewsbury Rugby Union Football Club, which will be listed on my handout, was a civil case. Essentially, somebody had had an accident. They said that accident was traumatic and they needed an intermediary to help them in the case. And the judge in this case made clear that a ground rules hearing was not necessary and not mandatory in the civil arena, although they did in fact order a ground rules hearing because it was agreed by both of the parties. What's more, an intermediary was agreed by both of the parties, and so the judge ordered it. But the judge, on his own volition, actually tempered the role of an intermediary and took away some of the powers an intermediary would have in the criminal cause. For example, that intermediary was not allowed to intervene if the intermediary felt that the ground rules were not being followed. The judge felt that was a matter for him or her. And the intermediary was not allowed to ask counsel to rephrase questions because, again, the judge felt that that was a matter for them. And so that's a good example of showing how a judge will be considering how it wants or he or she wants these adjustments in the court and will be tailor-making them. Moving on to an example in the employment tribunals, in Rackham and NHS Professionals Limited, essentially the claimant had some adjustments needed. The judge ordered that an expert report be prepared to consider what adjustments were needed, but ultimately, and I've discussed this before, the claimant couldn't fund it. So the claimant agreed with the respondent that they would just use freely available medical notes. Essentially, the claimant lost that case and appealed on the basis that they hadn't had the expert report that had been recommended by the judge. So the hearing wasn't fair. And the judge in that case, in the appeal case, did not uphold that failing to obtain an expert report was an error in law and did not uphold the appeal. And they laid out guidance for future cases. 1, what is reasonable must be tailored to the needs of the individual. 2, if a person is entitled to make a decision affecting the conduct of their case, it is not general for the court to second guess the decision that person has made. And 3, emphasis should be given to holding ground rules hearings. This is important because it shows that if you obtain prior agreement about what adjustments will be made before even entering in the court arena, it's going to be very difficult for that other person to appeal that decision. And so it is recommended that you have a think about what would be an appropriate adjustment and agree that in advance. On my handout, I've listed the key points from the procedural rules and cases, but I'm not going to cover those now because I feel like I've done it as we went along and there's a helpful summary in that handout. In terms of tips from all of this in how to deal with vulnerable witnesses proactively, again, I'm going to give you a bit of a pause to think about how you would explain following this seminar what tips you would take away from dealing with vulnerable witnesses proactively, and then I'm going to summarize some tips that I have thought of. Okay, so the tips from my recommendations are: do use the provisions from criminal and family court as guidance, but don't read them as law. You can tailor them how you wish. Do remember that vulnerability is not automatic based on a characteristic or a situation, and it depends on the outcome. And so consider what the outcome on the case will be. Use the discretional nature of the CPR and presidential guidance to your advantage, whether representing the vulnerable party. Whether representing the vulnerable party or the vulnerable party being your opposition. And if possible, as I've said before, seek agreement with your opponent before going before the judge. That really concludes my presentation. I have listed some further resources on the handouts, but I don't intend to go into those now, but do read them because they will be very helpful in dealing with these issues.
So just before we hand over to Brian, who's going to give his presentation on pre-trial preparations, perhaps just 2 points to take out of Isabel's presentation in particular. The first is that we are in new territory, and if that wasn't sufficient to cause us to be alert, That territory involves the exercise of a vast range of judicial discretion. And with that in mind, I hand over to Brian, who's going to speak to us about case preparation.
Yes, well, thank you very much. And can I begin by thanking Isabel as well, because she's given a helpful overview of the area, and she's made clear the interdisciplinary nature of this evolving subject matter. And it was interesting casting my eye over the attendance list for this seminar, because we have a very wide variety of practitioners, employment, personal injury, commercial, from both sides of the fence, employees and employers, claimants and defendants, insurers, and the like. And it is worth bearing in mind that CPR Practice Direction 1A takes up all of 1 page in the white book, with, as far as I can see, not a word of editorial commentary. So it is incumbent upon practitioners who may be dealing with a vulnerable witness scenario to be familiar with the areas of law that Isabel has outlined and explained, and perhaps Ed and I will touch on a little bit more, because if you do not familiarize yourself with the different sources outside of this single page of the CPR, you are likely to leave your client at a grave disadvantage. If the issue was raised, whether at a case management hearing, at a ground rules hearing, or at the trial itself. And what I find quite interesting is that the CPR amendment has been in place since April of this year. Almost all of the cases that I deal with on a day-to-day basis probably contain some element of vulnerability in terms of the claimant's position, because I only do catastrophic personal injury work these days. But I have not had a single instructing solicitor, a single judge, a single counsel opponent mention once the new CPR PD1A, that it might apply to the case, or that it might have implications for our area of practice generally. And I don't know whether it's because the introduction of this important rules change has just been sort of swept up or swept underneath due to the focus that we all have in trying to keep the show on the road during the pandemic. But it's quite clear that there is much room for further attention. And the division between Ed and I, as has already been explained, is that I'm going to be talking about really pre-trial preparation, case management stage, looking to the ground rules hearing. Whereas Ed, though there will inevitably be some overlap, will be looking at how those issues then carry forward into the final hearing and indeed beyond. And although Ed was far too modest, of course, to say anything about himself, having a leading silk who has experience in commercial work, employment work, ecclesiastical work, and who is known to be a top strategist in these fields of litigation, is going to be a benefit for all of us, and including myself, when we get to listen to him. So let me just start with this. Although I come, I suppose these days, from a personal injury perspective to matters, it's not always going to arise in the context of an injured claimant or a harassed claimant in the employment context. We could have a key witness in a case who is of low intelligence and functionally illiterate. And indeed, I did a trial about 6 or 7 years ago where my key witness at a personal injury trial was completely illiterate, and he had been too embarrassed, in fact, to mention that to anybody before the trial. We only discover it when he's in the witness box and he announces that he's unable to read his witness statement. My opponent, now retired from the bar, and I'm obviously not going to name him or her, decides that tactically it's a good idea to now present his case on the basis that the employer should never be allowing an illiterate person to be in charge of the 17-year-old apprentice who suffered a very unpleasant and serious life-changing injury. And really that became the focus of his case, to attack the defendant, but also the individual on a personal level, that he was illiterate, seeking to criticize him in the witness box and saying that he should have disqualified himself by reason of being unable to read, deliberately taking the witness to documents that he knew the witness would be unable to read, taking him to a risk assessment that the witness simply could not comprehend. Now, that's a point which obviously we would have liked to have acknowledged in advance and which would have required some planning. You may be interested to know that, of course, as you might expect, the tactic employed by my opponent utterly backfired in practice, and he managed to shift a case where there existed massive sympathy for the severely injured minor to the defendant and the insurance company by making personal attacks on what was a vulnerable witness. So we could have a key witness in a commercial case who, because of its ruinous implications, has suffered a breakdown and is anxious and depressed. A claimant who has pre-existing severe learning difficulties and lacks litigation capacity regardless of the subject matter of the case, but who has to give evidence. One could have, as Isabel pointed out, a 17-year-old witness, a young witness, who has perhaps critical, but he is the sole eyewitness to an accident that might have killed a family member. And in that sort of scenario, it's likely that that witness may have vulnerabilities that need to be explored. And the headline point to my talk today is, please leave today knowing that this isn't just a matter that can be left up to the trial judge, and it's for trial counsel to get on with it and make the appropriate submissions on the day. That is not good enough. And I'm going to talk about how we can best deal with that at the pre-trial stage. And one of the first and foremost ways of putting your client in the best position is to make sure that you have digested the important sources. Maybe if you're instructing counsel to attend the hearing, to make sure that they know where to look for the sources, because I'm afraid many you'll find of our colleagues certainly aren't going to be as familiar as they should be yet. CPR, obviously. Civil Justice Council document called Vulnerable Witnesses and Parties Within Civil Proceedings. So just Google that. I've got the link in the handout I've done. Vulnerable Witnesses and Parties Within Civil Proceedings. It's a 150-page PDF, and it's got a host of useful thinking material within it. Can I recommend that you find out the website of an organisation called the Inns of Court College of Advocacy, of which many civil barristers are completely unaware. It's an organisation set up by the Inns of Court in 2016 to help with training and education in the fields of advocacy. And it is at the moment very much skewed towards advocacy in the criminal courts. But for the reasons Isabel explained, that's going to be very useful. And there is indeed a training module that anybody can access and discover how they're dealing with it there. Can I ask you to be familiar, or at least know that the criminal procedure rules exist? Just as we have a CPR, our criminal colleagues have a CPR, and it's part 18 of the criminal procedure rules, not dealing with further information, as we civil practitioners are aware of, but dealing with vulnerable witnesses. And they have practice directions, part 3D, all worth a look to be argued by analogy. Can I also point you in the direction of the Equal Treatment Bench Book, which has a wealth of information within it, again, perhaps more geared to the criminal context. But I think in terms of advocacy at pre-trial stage, case management stage, the civil judiciary will find themselves drawn towards the Equal Treatment Bench Book as a persuasive source. And so a good advocate would certainly be seeking to point a judge in that direction. And can I just say this, repeat a paragraph, in fact, that I find from the Inns of Court College of Advocacy website when they're dealing with vulnerable witnesses and advocacy. And I'm going to read it out because I think it is a critical paragraph in terms of how we think about these issues. It is recognized that our adversarial system must permit challenge of crucial evidence. It should not encroach on the rights of a defendant to challenge the evidence against them or her in a fair and appropriate way. The skill is in allowing this to be done without exploiting or taking unfair advantage of a child or a person with a vulnerability. At case management stage, when you're preparing, when you might be getting ready to gear up for an argument on what precautions need to be taken, say, for a vulnerable claimant, both sides need to bear in mind that it is not enough simply to say that the claimant will find it a trying experience. The defendant has to be permitted to challenge crucial evidence that that witness might give. And therein lies the key to open the door of a balanced case management decision, and then ultimately, one hopes, the trial. So I can't cover every angle at pre-management stage, but let me just lead into it on the more specific points I'm going to deal with by saying this. There may be some practitioners, obviously not those at this talk, but perhaps your opponents, who might try either to take advantage of the principles surrounding vulnerable parties and witnesses, and in some way to take a partisan position at the expense of the merits of the situation. Well, as far as I can tell from discussing matters with my criminal colleagues, at the criminal bar and in the criminal courts, the judiciary has a firm expectation that there will be a cooperative and objective stance taken. And my perception is that if parties on either side, either those seeking to rely on a vulnerable witness or those seeking to undermine that witness, doing and furthering their client's interests, seek to act in a cynical way, either by exploiting vulnerability or by seeking to featherbed a witness unnecessarily, you could well be subject to judicial criticism and public judicial criticism. And so I would suggest that you almost overtly try to show to opponents and to the court, when these matters are first being raised, that you are to be cooperative and that you will seek to further the overriding objective of seeking equality of arms, which ultimately is perhaps what this is all about. And equality of arms forming a feature of the overriding objective, both in tribunal and in the civil jurisdiction. So the next point is, raise it at the very latest, if you can, by case management stage. The problem of leaving it to trial is, first of all, if there is a significant disagreement between the parties as to what precautions should be taken in respect of a vulnerable litigant or claimant, it will hijack the start of a trial. And all of us attending this talk knows that trials never run to plan anyway. There always seems to be something at the outset of a trial, whether it be an application for further evidence, because the bundles haven't transmitted properly, because somebody's not turning up, and a host of other procedural grumbles that we sometimes need to deal with. What we do not want is for a trial judge to have to deal with the subject without adequate warning on an issue which really could have been dealt with weeks, if not many moons ago. As much as anything else, you're going to have an unhappy judge, and Ed will perhaps be telling us more about having to keep the judge happier than that. And we don't want to risk an adjournment, because we don't really know in this situation where the costs are going to lie. And if you've got a 5-day trial with your costs incurred, it's a disaster for everyone, including a vulnerable litigant, if everybody walks away, perhaps with a no costs order, because the judge decides that it's a plague on both houses for a failure to deal with at an earlier stage. And as Isabel pointed out, paragraph 6 of the new Practice Direction 1A mandates that the court and parties have to identify at the earliest possible stage of proceedings, earliest possible stage. And so I say, flag it up in correspondence to begin with if you know there's going to be an issue, because then, of course, you can never be criticised for it being raised too late in the day. If it's actually a litigant in the case, I would suggest you could consider actually raising it in a statement of case, in a particulars of claim, in a defence. And you might think, well, that's an odd place to raise it. But of course, as I always try to remind those I'm working with, a particulars of claim is the first document that a judge will usually read, whether it be at case management stage or trial. And that's why it's so important for it to be well drafted, beautifully presented, but also put into the judge's mind key factual points. And one of those might be a problem with an individual witness. The directions questionnaire, part I, has a whole section dealing a big box on the standard court form with information you help the judge to manage the claim. It's an obvious way of raising the issue. And of course, before a cost and case management hearing, which we have in any significant case in the civil courts, parties put in case summaries, sometimes position statements. And I would suggest that if there's going to be an issue over a vulnerable litigant or witness, that it may need to be flagged up in a case summary, and perhaps in an expanded one or in a position statement, to help the civil judges who are as yet relatively unfamiliar with the concepts involved. And they might have gone to a short online training course in the past year, but they might not, and it might not have stuck in, and they certainly will not have detailed knowledge in most cases of the analogous criminal and family procedures, which perhaps have much more detail as to how these can be dealt with. So you need to identify concisely what is the nature of the vulnerability, what basic evidence there might be to indicate that in an objective fashion, and a broad indication of the type of directions that might be sought to remediate the issue that arises. And the question then arises, well, having warned against kicking the can, in effect, down the road to trial, might it be appropriate in some cases just to have a district judge at a cost and case management hearing record that there is a vulnerability and that steps might need to be taken? And so you could have a preamble to an order, and upon the court identify that witness Mr. AX being called for the claimant is a vulnerable witness by reason of suffering from a borderline personality disorder, there shall be modifications to the procedure at trial as the trial judge might think fit. At the very least, that means that a trial judge and the parties can't forget about it because it's within the preamble. And perhaps if it was a very short witness, not of enormous significance in the case, but still necessary to call, that might be enough. But for a witness of substance, who may need to be taken to many documents in the case, or is giving evidence about events lasting 6 months to a year, whatever feature might make it a more complicated situation, it's going to need to be dealt with in a more careful fashion than that. And the next point people will wonder is, well, can I just deal with it at the CCMC at cost and case management stage? Now, the same will apply to a CMD hearing in an employment tribunal. But the problem is this: the judge has got so many other issues to deal with in the 1 hour, 1.5, 2 hour listing that she's been given, that I do have grave concerns that with a new and evolving area of law and procedure, that it's going to be satisfactorily dealt with. You've got cost budgeting to deal with in the civil courts, in the employment tribunals, where I still sit from time to time. Much of the time is taken up wrestling with trying to identify what the actual issues in the case are going to be, often leaving very little time for actually setting the directions timetable through to a hearing. So you're going to need, in anything that isn't a simple situation, probably, I'm afraid, a separate, exclusively focused grounds rules hearing, GRH. I just don't think that's possible of escape. And many parties will say, well, it's just another hearing, it's just another expense. And it might be, but how do we prevent it from becoming a type of parasitic expense of litigation? Well, first of all, I know there is no model direction yet. So I'm going to tentatively throw out a few suggestions for you to think about. First of all, it's got to have a strict time limit. We do not want half-a-day ground rules hearings. My submission would be a 1 hour hearing, but exclusively focused on that issue. And it can be budgeted in the civil courts as a contingency phase within the BDR, the precedent age. Parties should be expressly directed by a judge to cooperate and discuss the ground rules for the vulnerable party ahead of that hearing. Even say what measures they agree on and what they don't agree upon. And perhaps the parties being ordered to file any evidence bearing on the issue, whether it be from a medical expert or an intermediary 3 days in advance. And you might, in that respect, want to have regard to Rule 3.9 of the Criminal Procedure Rules, which gives a bit more detail of the court having to discuss proposed ground rules and directions with the parties and any intermediary, setting the ground rules for the conduct of questioning of the witness and any other directions as may be required to facilitate the effective participation of that witness or defendant. So refer the judge to Criminal Procedural 3.9 to assist with setting a cost-efficient, proportionate ground rule hearing. And at that ground rule hearing, although it's perhaps more for Ed to talk about how it will go into practice towards trial, it's going to be general adjustments for the witness, which could be the simple matter of a screen, but could actually be putting certain subjects off limits. And actually the extent of steps that can be taken is going to raise the eyebrows of many civil practitioners who might think, well, we can't possibly be expected to protect our client's position with the opposing witness or opposing litigant being protected. You might need documents read or explained. There may be a need for agreed facts, time limits on questioning. And one important point that I think I'll leave to Ed, because I think it's a very interesting subject matter, is directions in the forms of questions that might be put. And that will lead to a sharp intake of breath for people who practice in my field, who are used to seeing sometimes vulnerable people being robustly cross-examined, where there may be limitations on the tone of questioning, open rather than leading questions and the like. Very different. And what I would say is this: there's going to be a need for better quality advocacy. I'm afraid those barristers that you use who get away with a bullying form of advocacy won't be able to get away with it, because they're going to have to change the style of how they put their questions so very severely that you're going to have to be very careful as to who you're using. You're going to have to consider about the intermediary, and the concept of an intermediary is utterly unfamiliar to most of us who practice in the civil courts. Often a speech and language therapist, SALT, who's skilled at assisting, let's say, a brain injured claimant with communication. And how the intermediary is going to be used needs to be discussed at the ground rules hearing. Who's going to select the intermediary? Who's going to pay for the intermediary? These issues have not yet been explored. And I suspect that while there's much to be said for having the court, the Ministry of Justice pay for an intermediary, that's not going to happen in practice. So can I just note 3 problem areas before I pass over to Ed? First of all, sensitive medical history and causation, an issue that's going to have to be dealt with. And let me just give you one example as a case study from a real case that I've done. 13-year-old child with a very serious spinal injury, pre-existing psychiatric issues in childhood, separation anxiety and the like. The spinal condition, although very serious, after surgery starts to recover, and by age 16 it seems to be quiescent, in that it's not remarked upon within contemporaneous medical records. When the claimant turns 18, her medical records reveal that the claimant has been subject to a most serious sexual assault, the most serious that one can imagine. Soon after that, there is a recurrence of serious back pain. And the expert's view is that the back pain is a manifestation of psychiatric disturbance rather than the underlying organic pathology in the spine. Now, in that scenario, the sexual assault and its impact upon the claimant and her perception of pain and disability lies at the very heart of the case. It could be the $1 million issue. How does one deal with that? We can never leave an issue like that to trial. And I'm not going to give firm answers here because these cases are always fact sensitive, but that could be a situation where the only fair way to deal with it, to allow the claimant to actually play a part in the trial, could be to have it, that area of her evidence being dealt with by cross-examination in advance, perhaps even video recorded, almost equivalent to a deposition, so that it's out of the way. And we are entering into uncharted territory as to what that's going to mean. And let me deal with one other problem area that's just got to be wrestled with at a grounds rules hearing well before trial, and a case involving an allegation of exaggeration, malingering, or fraud. And it could be, it most obviously arises in a PI context, but could easily arise in an employment context as well, where a claimant is alleging serious psychiatric sequelae from a course of harassment. Now, one can easily grasp the tension between seeking equality of arms and having a fair trial. Because if the defendant's case is that the vulnerability is an invention, is being made up, is a device to aid the claim for damages, as well as a protective device to prevent the claimant from being properly tested at the trial, a judge might seem to be in an almost impossible situation. Anything that the judge does might upset the level playing field, a concept that in personal injury, serious personal injury work, we're very familiar with. And I tentatively suggest there that with that sort of situation concerned, a judge at a ground rules hearing is going to have to look at the substance of the case to see whether there is an issue of substance for the claimant to have to address in terms of his vulnerability and the allegation that claimant may lack integrity in terms of what he is contesting. And the judge is then going to have to decide whether there are to be light touch restrictions, which would allow a defendant to pursue an extensive and more robust cross-examination, or where a claimant is going to be more carefully protected. But one may yet have, let's say in a subtle brain injury case, a robust cross-examination, but with short, direct questions, without tags and the like, that Ed may be in a position to speak more about. And that will need good technique on the part of the advocate, where we have rigor, but also easy comprehension. So I wish you good luck when you have your first case that deals with it. Grasp it ahead of time. Don't kick the can. Pass it to Ed.
Thank you, Brian. If I could just begin by identifying for the benefit of those who are participating in hearings, whether it's a trial in a civil court or whether it's a hearing in a tribunal, and whether that's at the MPTS or whether it's the employment tribunal or anywhere else. We are not here talking about issues of witness competence, and that's a really important point. And there will always be a tension for us who represent organisations, particularly respondent or defendant organisations, where, and we have seen this played out in particular in the area of personal injury litigation, or for that matter, litigation around disability discrimination of various kinds. Is this claimant presenting with an authentic problem? Is this claimant presenting with an authentic medical condition, which operates as an impairment in the way that they would describe. That's the similar exercise that we as practitioners are required to engage with when considering the issue of vulnerable parties and witnesses. And the reason for that, as Brian has already alluded to, is the tension between the need to facilitate, and that's what we're talking about, facilitating the reception of the best evidence that the court may need to adjudicate upon the issues which are central to the case on the one hand, and ensuring that for the benefit of our clients, the issue of vulnerability does not serve as either a parasite in terms of duplicating or generating costs which are disproportionate, or for that matter serve as a Trojan horse to secure some unfair, disproportionate procedural advantage. And I should just add, by way of preface, that Brian has indicated very helpfully that these issues are matters of professional responsibility. They are also issues now which have the potential to incur or generate a professional liability. And Brian alluded to the fact that there have been practitioners in the past who may have adopted what can only be described as the rumpole style of advocacy, of being very robust and confrontational with the witness, not demonstrating any sensitivity to either the subject matter or the subjective characteristics of the witness in question. That, I hope, ceased to be acceptable some time ago, but perhaps to underscore that point, it's important for those who practice in civil litigation to understand that that sort of behaviour in the context of vulnerability is likely to generate A, adverse cost orders, B, professional referral, because it would be considered inconsistent with your duty to the court, and a breach of the bar code of conduct or the solicitor's code of conduct. It will also be considered to imperil your client to the risk of aggravated damages, because you have entered into a territory where, in the view of the tribunal, you should not have gone. So by way of example, I was required recently to cross-examine a very senior accountant, and the case involved disability and in particular mental health. And it will come as no surprise to you that in the majority of these cases, the issues are not around physical impairments. The issues are around cognitive issues, or perhaps dyslexia, or for that, mental health difficulties. And it's really very, very important to grasp at the outset that we are not talking about adjustments under Section 20 of the Equality Act 2010. We're talking about the obligation on the part of the court to facilitate the reception of the evidence from that party, from that witness, and the obligation of each of the advocates to facilitate that exercise and to collaborate for that purpose. So when Isabel was alluding to core concepts like access to justice, transparency, and Brian alluded to equality of arms, it is that balancing exercise that is being played out in this particular area. And there are two questions that I'd like you to keep in mind as I go through my presentation. And the first is this: why are we traveling in this direction? What is it that's motivating the courts and tribunals to adopt this method? And the second is, what is our likely path of travel? And so just to lay down a chronology, perhaps, we know that prior to February 2020, and that's the date of the Civil Justice Council report to which Isabel has made reference, parties may have relied upon a number of statutory provisions in order to lay claim to the right to a fair trial or the right to participation in the legal process. And you will all be familiar with Article 6 of the European Convention and Sections 3 and Section 6 of the Human Rights Act, which imposes obligations on the part of the court itself as to how it both interprets and applies legislation. And then, of course, there are provisions under the Equality Act 2010. But what we saw prior to February 2020 was, in fact, as both Brian and Isabel have confirmed, jurisdictionally specific regimes. So we were familiar with the idea that there were specialist rules that applied to family proceedings. We were familiar with the idea that because of the subject matter with which the criminal jurisdiction is required to engage, there are special rules there and special measures, in fact, for the reception of evidence the facilitating of witnesses giving evidence by special measures and remote means. And in those circumstances, of course, that's not just about vulnerability in the wider sense of disability, it's actually a much more specific notion of fragility, and in circumstances where, but for those measures, their evidence would not be received. So there were, prior to February 2020, recognised categories of beneficiary of these measures. So for instance, children, victims of sexual offences, and other forms of victim in criminal proceedings. In February 2020, the Civil Justice Council published its report, and Brian has already given you the title, Vulnerable Witnesses and Parties Within Civil Proceedings. And they had this to say, and this is set out on the slides that will be circulated. They defined the issue in this way: access to justice, just procedures, and fair hearings are essential elements of our justice system to ensure the system works properly. Such elements need to cater for parties and witnesses who, by reason of mental or physical disability, disorder, impairment of intellectual or social functioning, fear or distress, or other reason, are vulnerable, such that their ability to participate in proceedings or to give their best evidence may be impaired. That's quite a list. Excuse me. So we have mental or physical disability, we have impairments of intellect, we have impairments of social functioning, fear or distress, and we have other. And it's that other category which is likely in the final analysis to be engaged most frequently, where people may find that they have an underlying condition or difficulty, but it's in fact the stressors which are generated by participation within the litigation that magnify that difficulty or amplify the impediment that they might otherwise be subject to. And the problem, as the Civil Justice Council identified it, was quite simple. And it was this: there was no specific rule dealing with this situation across all jurisdictions. They attributed this to a passivity on the part of the judicial system, an inadequacy of reaction, and they made the observation that the judiciary was being insufficiently proactive and equally insufficiently consistent in the way that these matters were engaged with across the jurisdictions. And curiously, those sentiments were expressed by reference to involvement in a process. Now, there is a tension here, bearing in mind that we are not talking about a claimant who is lacking capacity. Clearly, that might be an issue for the Court of Protection. But as far as we are concerned, we're talking about somebody who has voluntarily embarked upon litigation, or has voluntarily chose to pursue a course of action, or may in fact be voluntarily giving evidence to support somebody else in doing so. And what's quite important is that these vulnerabilities may present themselves as issues for the litigants, claimant or defendant, but it could equally be the person who is supporting the claimant or defendant. And certainly I've had reported to me recently a case in which the judge made adjustments in the conduct of the hearing, both its form and its content, not because the claimant herself had a difficulty, but because in actual fact, the person who was supporting her husband, had a profound disability. And that adjustment was of a psychological kind to ensure that the number of people in the tribunal were restricted so that the accompanying individual didn't feel overawed, or for that matter, overwhelmed by the procedure itself. So the Civil Justice Council said, there's the problem, how do we address it? And the first recommendation they made was for the production of procedural rules. And as Brian has already mentioned, we end up with the amendment to the Civil Procedure Rules, a model of brevity that it is, and full of promise, but not necessarily guidance or explanation. What they also recommended was that the courts and tribunals should utilise or revise their forms and utilise questionnaires, so that when parties are being asked online to complete forms for legal proceedings, that they were asked whether they had a disability or a vulnerability. And the problem with that, of course, is the point that Brian has already referred to. People will not necessarily volunteer that difficulty. They may not be aware of it themselves. And so that presupposes that that issue is something of which they are cognizant and are able to request assistance. And particularly in the area of mental impairment and mental difficulty, people still associate a social stigma with certain medical conditions. And the other factor that was subject of recommendation by the Civil Justice Council was training for the judiciary. And I can tell you that that is actually underway. So the training for the judiciary is being rolled out, not, as it were, to make to equip each judicial office holder with the ability to carry out diagnosis or assessment of witnesses, but in fact to enable judicial office holders to be alert to the possibility. There's a phrase that I'm going to come on to later, to be alert to the risk that somebody within the procedure itself may in fact have an impairment which serves as an impediment to their participation in the process. Now, if we just pause there for a moment, you will see when you receive the slides that I have included a number of quotations from judges as to how they see the evaluation of evidence from witnesses. And there's in particular a quotation from Lord Bingham, which reads as follows: that the ability to tell a coherent, plausible and assured story, embellished with snippets of circumstantial detail and laced with occasional shots of lifelike forgetfulness, is very likely to impress on any tribunal of fact. But it is also the hallmark of the confidence trickster down the ages. Now that is a kind of skepticism that we might be approaching this issue with. And you may well recognize that at the start of the pandemic, when the courts were wrestling to conduct legal proceedings by alternative means, many practitioners, myself included, had grave concerns about what does this do to the integrity of the evidential process? How do we monitor people giving evidence remotely? How do we know that they're not reading something else on screen whilst giving evidence to the court or tribunal? How do we know that they're not being prompted? Those matters don't go away simply because we're dealing with issues of vulnerability. The other quotation which I'd like to share with you is the observation of Mr. Justice Leggett in the Guestmin case. And he said this: in the light of these considerations, the best approach for a judge to adopt in the trial of a commercial case is, in my view, to place little, if any, reliance at all on witnesses. Now that might be, as it were, a short cut to judicial economy, but it's also an accelerated path to appeal. And what we're actually trying to deal with here is, how do we protect our clients' interests? How do we make sure that our clients are not going to be wrong-footed, either in the preparation for the hearing, or for that matter, on the first day, as Brian alluded to. Things often occur on the first day, not least, well, I actually don't want to play by those rules anymore. And it's important to remember that whilst we're talking about vulnerable parties and witnesses as though they are benign and receptive to any measures that might be proposed, we also have to be receptive to the notion that there are cases where the individual will be resistant to the measures that the court or tribunal is proposing, particularly when it comes to the disclosure of medical evidence to authenticate the impediment upon which they rely. So as far as the judges are concerned, how are they being guided? I mentioned judicial training. How are they going to be guided? Well, the primary source of guidance is in the Equal Treatment Bench Book. It's accessible on the internet, and the most recent publication was issued in February this year, and it seeks to articulate and give effect to a number of the matters that we're talking about now. And what is key to this regime is set out in paragraph 31 of chapter 6, and it says, ideally, courts and tribunals should have systems for identifying at an early stage, this is Brian's point, at an early stage and before the final hearing or trial, whether any adjustment for disability will be required, and whether it's a question on the standard claim form for the court to question, this should be checked by judges or caseworkers at an early stage. So the sentiment here that's being underscored repeatedly is around forward planning. And there are a number of other resources that you might wish to look at. One of them is the charity Mind. They have published material which identifies, for the benefit of the judiciary and legal practitioners, those likely indices of enhanced stress, difficulty, and so on for vulnerable witnesses, and they include rather helpfully the following list, which you may consider to be inconsistent with giving evidence at all. The first is noise, the second is interruptions, being asked to concentrate, time pressures, authority figures, questioning, and feelings of not being listened to or believed. That sounds like a fairly comprehensive list of taking part in an adversarial process, but that's the list which they exhort the courts to have regard to. There is another resource which is quite important, and that's the Advocate's Gateway. And like many of the materials which are available, as Brian has already alluded to, these materials are primarily directed towards criminal practitioners. But this gateway was established in 2012. And whilst you may think, well, actually, I'm not a criminal practitioner, I'm a regulatory lawyer, I do GMC work, or I'm a commercial practitioner, I go to the business and property court, or for that matter, I'm an employment practitioner, I don't need to know what the criminal courts do. Wrong. As Brian has already said, and as Isabel has already referred to, this is a process of procedural change by analogy. And the reason why there is no detailed guidance being given is because this is an ad hoc exercise. This is a fact-sensitive judicial obligation to engage with the parties that are before the court or tribunal in a very specific way. And the Advocate's Gateway also has a number of toolkits, and you will see on the slides that I've created that they have the numbers of the toolkits recited. The most relevant here are toolkit number 1, which deals with ground rules hearings and fair treatment, and toolkit number 10, which is concerned with identifying vulnerabilities and making adjustments. So in terms of case management, then, the judge receives the case on the first day of the trial. Hopefully, there would have been some case management. Very often there isn't, because of course there is the possibility that the litigant, or the witness for that matter, is only manifesting a particular difficulty in an evident way on the first day of the hearing, or that they're with a family member who's decided to disclose the position there and then for the first time. So let's just pause and think of some practical examples. Certainly I was involved in a case where it wasn't the first day of the hearing, it was day 3, and as my witness was going forward to the witness box to give evidence, the client leant forward and say, by the way, you do realise that he has Alzheimer's. That has an important practical consequence, not only to your own stress levels and blood pressure, but the point that is being made here, of course, is knowing your own witnesses, being alerted to those difficulties, enables you to protect your clients against 2 things. One is the risk of inconsistent or contradictory evidence. The second is, in fact, the decision not to call that witness, and managing the case of Wisniewski, which deals with the ability of the courts or tribunals to draw adverse inferences where important witnesses are not called to give evidence. So knowing your witnesses, knowing your client, and cultivating a relationship as part of the pre-trial preparations, as you all will obviously, and cultivating a relationship which gives the client or the witness the opportunity to disclose those sort of difficulties, even if it's something as innocuous as, you know, are there any particular adjustments that you would like in order to enable you to give your evidence more confidently, that might prompt a discussion around adjustments for that person. And in terms of controlling the reception of the evidence, the key message of all of this guidance and the Equal Treatment Bench Book is that these measures should demonstrate bespoke attention. This is bespoke attention to a particular vulnerability in the context of a particular case, preserving the flexibility of the proceedings, but whilst giving both the adversary parties to the litigation the opportunity to present their own cases. Now, that immediately places us into difficulty with the notion of judicial intervention, judicial activism, because as Brian has mentioned, there may come a time, and this is a fact-specific issue in each case, but there may come a time where the judge will have determined that the evidence of a particular witness should be received in relation to certain issues only. And of course, that has to have the corollary that means that you as an advocate should be expressly informed on the record, so to speak, that you and your client are being exonerated of the duty to put any case on that issue to that witness and will not be held hostage for any failure to do so. Speaking personally, I'm always anxious and not a little nervous when a judge or tribunal says, well, you don't need to put your case on that point to that particular witness, particularly when it transpires that that is the key witness in the case and the tribunal or court just hasn't read the paperwork. But there are other factors which need to inform our assessment. And it's essentially that we as practitioners have to carry out our own risk assessment. That's what we're actually doing. It's a risk assessment. Where does the balance lie? And by being proactive, which is a point I'm going to come on to in a moment, as Brian has mentioned, by being proactive, you are in fact providing the court or tribunal with a solution, which might in fact be very, very simple. So I said I would give some examples. In one case, an employment judge sitting in Birmingham, a member of these chambers, was told that if the claimant was called into tribunal to give evidence, he would actually throw himself out of the window. And for those of you who are familiar with the building, it's a multi-story building. And having checked the file, the judge satisfied himself that there was a mental health issue. So the hearing was conducted in the waiting room and involved the judge and all of the other advocates removing any jackets or ties or might give the appearance of legal formality. And the hearing was conducted in that way. It didn't in any way undermine the integrity of the process or the judge's ability to assess the evidence, but it shows that what the judges are being asked to do here, and this is a key message in terms of both the judicial guidance and the Equal Treatment Bench Book and the Civil Justice Council, is to be creative. This is, as far as the judiciary is concerned, a call to creativity. And we might think, perhaps sometimes in almost Pavlovian way, well, that means we have video links. It means that we have interpreters. It means that you may have an intermediary to support somebody or page turner. But it might be more extensive. It might be in those jurisdictions where a judge would ordinarily sit alone. It might be appropriate for the judge to consider appointing somebody as an assessor. It may be relevant for the hearing or that part of the hearing to be conducted in private, or for that matter, additional IT facilities to be held are made available. So one would hope that all of those things had taken place, implemented, ready to go on day one, but sadly, invariably, that's not the case. So one then looks at that principle of best evidence, and it's important to bear in mind that whilst many of these principles are migrating across from the criminal jurisdiction, that's a jurisdiction in which people lose their livelihood and their liberty. And it will be very difficult in a civil jurisdiction to say, well, that is a disproportionate measure because that deprives my client of a right of fair trial. The prospect is the judge is going to give you some degree of pushback, and she will say, no, if these are acceptable in cases where there is a loss of liberty issue, then they're acceptable in the administration of a dispute of this kind. But looking at practical matters, the judge, once they have been alerted to issues of vulnerability, is going to want to know on day one, how am I going to timetable this case? How am I going to ensure that those ground rules, which should have been set out in a hearing previously, how do I ensure that those ground rules are adhered to? And certainly my own experience very recently is that there was a ground rules hearing which took 3 days. 3 days. And that was in order to avoid having a 35-day trial in circumstances where, in actual fact, we would still be none the wiser at the end of the process as to what the claimant's case is really about. So a judge is going to be anxious, and not to say determined, to understand not only the nature of the case and the level of participation, but the practicalities of receiving that evidence. So simple things. When is the witness best able to deliver their evidence? When do they become most fatigued? When are the symptoms of which they complain most likely to operate upon them and undermine their ability to participate? So that obviously informs basic matters such as the duration of sitting hours, but it might also be about the timing of questioning. It might also be about rest periods. Those are the sort of things that courts and tribunals are familiar with as a result of the Equality Act. But in actual fact, the Advocate's Gateway checklist is far more extensive, and it talks about the location of the hearing in a very elaborate way, and in fact accommodates the possibility that a special measure arrangement might be for that witness either to give evidence by deposition in the way that Brian has alluded to, or alternatively, for that person's evidence to be received by them being interviewed at their own home in an environment which doesn't cause them anxiety. And so this is really one of those situations where, in procedural terms, you could say anything goes, or in fact, does it? And this is where we turn to the toolkit, which is available on the Advocates Gateway, the GRH toolkit, and this is set out in the slides that you will receive. And there is a list of factors which are identified. One of them uses the term the court's safeguarding responsibility. And that tells us that we are in the territory of making provision for the welfare of those who are gaining access to the justice system. But what it makes clear is that whatever the ground rules are, they should in fact be recorded in writing, and they should be adhered to unless there is a very good reason. Now, one very good reason is on the first day of the hearing that the witness or the party is manifesting symptoms which are in fact far more severe, far more difficult, far more problematic than have previously been demonstrated. It may well be in actual fact that those measures that were thought to be adequate are not adequate. And that pinpoints an important factor in this whole exercise. These are matters of risk evaluation, which the judge is required to keep under review. And it's interesting that in this toolkit, one of the recommendations, and this appears in the Equal Treatment Bench Book at paragraph 78, in more severe cases, sending questions to the witness in advance is a measure to accommodate vulnerability, or for that matter, disability. Now, it may well be a personal reaction, but for me, that seems to take stages very far indeed away from the sort of notion of equality of arms. So, for instance, in a criminal jurisdiction, if there was a notion of giving the claimant, the witness, giving the claimant questions in advance, that would usually be with the assistance of an intermediary who would translate the questions to a form which was acceptable, receptive, bearing in mind the impediment or vulnerability of the witness. And that goes to the point that Brian was making earlier about tag questions. This is about simple sequence questions which are able to be absorbed and responded to by the witness. And it's interesting that within the criminal jurisdiction, that intermediary is able to make representations to the court as to the form the questions should take and their duration and other matters concerning the ground rules generally. But also when those questions are shared with the intermediary for the purpose of the ground rules hearing, they are not shared with the opposing advocate. Now that's very, very different to the sort of experience which you may encounter in the employment tribunal. And some of you may wish to look at the case of Michalak, a case in which a doctor recovered in excess of £4 million by way of damages. And in that case, the employment tribunal directed that all of the questions that the advocate for the respondent trust wished to put to the claimant should be sent to her in advance in writing. And it's difficult to reconcile, you may think, difficult to reconcile that notion with the adversarial process, which so much of the information recognises is an irreplaceable part of our legal system. There is also a document that's been published called Advocacy and the Vulnerable, 20 Principles of Questioning, and it's published by the Innsbruck School of Law, and it has 3 principles, and again this is on the slide, but it talks about vulnerability includes immaturity. It emphasises the point that every case is unique, and it talks about principles for questioning and includes the exhortation to avoid statements put as questions, pronouns, remembering questions, and no directive questions. So we're talking about questions which are reduced to the absolute bare minimum, and they take some thinking about. They perhaps demonstrate the old adage, if you want me to write something shorter, you need to give me more time. So as far as advocates are concerned, it's a completely new style and new way of approaching matters. So Let's place ourselves in the context of the final hearing. What should our strategy be in preparation for that hearing, and what should our strategy be in participating in the hearing itself? And you will see when you receive the slide, I use 3 terms: identify, initiate, respond. So identify the court or tribunal's case management powers. And it may well be that you find that the court's powers are extensive and unlimited, and that gives you opportunities as well as the tribunal. Identify and authenticate the concern. Identify, it goes back to the point that Brian made earlier. Is this impairment, is this impediment or difficulty authentic? Is this affectation? Is this a feigned difficulty in order to secure some procedural advantage? And of course, many practitioners who participate in the employment jurisdiction will know it is often the case that the employer will say, we do not admit that this person has a disability, because of course, until they have seen the underlying medical evidence, they can't make value judgments as to when, how, and what circumstance that medical condition began to operate upon that individual. Identify the evidential basis of the concern. Is it well-founded? Is it conceded? And this goes to Brian's point about not just appearing to be collaborative, but be proactive. The more proactive you are, both in the preparation of the hearing, the greater control you're able to exercise in the hearing, and the greater the protection you're able to give your client for that purpose. And that means that being protective to your client means initiating procedural safeguards for your client. Offering the tribunal or offering the court proposals may, in fact, as far as the court or tribunal is concerned, be received like manna from heaven. It may be the only input they get. And Brian mentioned earlier the fact that notwithstanding the extremely complicated litigation that he's involved with, and the experienced advocates who he often appears in court cases with, this issue has not been raised, even when there is manifestly a difficulty as far as that party is concerned. That is much easier to do on a proactive basis in a manner which is consistent with managing the expectation of your clients than being on the receiving end of something which is generated in court and is seen as a challenge to your client, or for that matter, potentially received by your client as a predetermination or an expression of sympathy for one party before the case has been heard. So the next question, how do you respond? Well, you respond by asking whether the measures proposed are proportionate and fair. Do they need to be continued? So do the ground rules that applied at an earlier stage of proceedings need adjustment? Do they need to be continued? Do they need to be adjusted or refined or abandoned? Can the same result be achieved by other means? Is it possible, for instance, that if a claimant says, well, I have difficulties in concentration, please send me all of your questions so I can study them at home with my relatives, the response to that might be, well, we can address that. We can have evidence given in installments, more frequent rest periods. We may have, in fact, questions put in a more succinct way. We may limit the range of questions that are being asked and the reason for them. And that takes me to the final point in this general strategic overview, and that is to ask yourself the question, can this be resisted? Should this be resisted? So what's the this? The this is excessive judicial control or limitation. Has this gone so far that this looks like it's a predetermination of the case? Is this in fact imperiling my client's ability to marshal their defense or marshal their claim? And is this conduct which is being proposed by the judge, or is this behavior that the judge is demonstrating, in fact, one of those cases where the judge is entering into the fray? And we used to have techniques of raising judicial awareness of this. One phrase that I heard one practitioner say, to object to an objection, to object to an intervention on the part of the judge, to say, I'm minded of the story of the referee who ran with the ball, at which point the judge continued running. But the point is quite important, because like many of the cases in this area, whether we're talking about civil litigation generally or we're talking about employment, if you do not intervene and offer the court or tribunal an alternative pathway, that will be set. And your opportunity to appeal, for reasons I'm going to come on to in a moment, will be extremely limited. So, challenging decisions. For many of you, you will be practicing in areas of law where there is a statutory limitation on the appeal, and that is usually a precondition that the appellant must satisfy the appellate tribunal that there has been an error of law. And so, likewise, in civil litigation, we're all familiar with CPR Part 52 and the quite high threshold for appeals against judges, and in particular appeals against judgments or rulings which are of a procedural kind or involve the exercise of case management discretion. And the rare challenge, and it's a rare challenge in the sense of being like hen's teeth, is the successful challenge by way of appeal in respect of a finding of fact. Now this kind of takes us back to where we started. These are not procedural accommodations that have no consequence. They have the potential to distort not only the fact-finding inquiry, but also consequentially the fact-finding determinations that the court or tribunal is likely to make. And appealing those findings of fact is immensely difficult. And as Lord Neuberger said in Read B, and this is on one of the slides, this can also be justified on grounds of policy. Parties put forward their best case on the facts at trial and not regard the potential to appeal should not regard the potential to appeal as a second chance. So what does that mean in practice? It means that you have to satisfy the appellate court there's no evidence to support that particular finding. Well, that's going to be quite difficult. In fact, you didn't put the case to the witness or party because you were given a steer by the judge that you didn't need to. The second ground, you might be able to say that the finding of fact was based on a misunderstanding of the evidence. But that, of course, is always sharply infested waters because that assessment of the evidence involves assessment of integrity and credibility and demeanour. And the third ground, it has to be a finding which no reasonable judge could have reached if the appellate tribunal or court is going to interfere with it. That's what we as employment tribunal practitioners tend to refer to as perversity. So it's not difficult to see that being vigilant in the conduct of the final hearing doesn't simply involve collaboration and passivity. It means being proactive in each step of the way to monitor the impact of the accommodations that are being made for the benefit of your client, to ensure that that equality of arms, that transparency, the access to justice, which have been previously referred to by all of the speakers today, is maintained and accommodated for both parties to the litigation. There are 3 cases which indicate to us a path of travel. Isabel has already referred to Rackham and NHS professionals. It's an important case. It's in the realm clearly of employment litigation, but still offers guidance to all civil practitioners on account of the transferability of these principles and ideas across all jurisdictions. And the second is the case of Shue and the University of Manchester and others, the case of a judgment of Ronald Judge Edius, who then was, in which the issue around mental health and whether it should have generated an adjournment was the basis of the appeal, and the EAT had to determine whether or not mental health was in and of itself a justified ground for granting an appeal. But I suspect of equal importance to all civil practitioners will be the case of J and K. And this case involved the lodging of an appeal and whether or not the appeal time had been allowed to elapse or hadn't been met on a number of grounds, one of which was the mental health of the appellant. And in giving judgment in the Court of Appeal, Lord Justice Underhill was at pains to point out that the principle of accommodating access to justice didn't require citation of wealth of legislation. It didn't require consideration of the European Convention on Human Rights. This was a principle of domestic law. And it was a principle of domestic law which required no detailed exposition. It was obvious. So obvious, in fact, that when being invited to give additional guidance as to how it might play out in particular cases, he declined to do so. But it is clear that what is set out in that judgment is the emphasis that where there are mental health difficulties operating upon a particular witness or on a particular party, and that they have the effect of undermining their ability to either participate in the procedure or, for that matter, to comply with a rule or direction within the procedure, that mental health issue, that vulnerability, will continue to serve as an important, albeit not determinative, factor in the exercise of any judicial discretion. So, drawing all of those strands together, I hope that through our presentation today, you've been able to see not only the genesis of these ideas, but the way in which they have, in a relatively short period of time, begun to migrate from what is in fact a very specialist jurisdiction, the criminal and family courts, across all jurisdictions. This is a form of judicial intervention which is now well established as being within the cohort of judicial responsibilities in the management of cases generally. It's our role as advocates, our role as practitioners, to ensure that our clients' interests are not diluted or undermined as a result of these innovations. And in fact, in order to achieve that end, our role is perhaps to help craft those innovations in a way which supports our own expectations, our clients' own entitlements of access to justice, so that there is true equality of arms and true principles of best evidence are maintained. I'll just turn to each of the speakers to see if they have anything to add before we draw our session to a close. Isabel?
No, I think it's been covered well. Thank you, Ed.
Right.
Just a question I've received by email, and that was to ask for examples of how at a ground rules hearing, or indeed at a trial, restrictions might be put on the nature of questioning. And so I'm going to give you some examples drawn out from the Intercourt School of Advocacy that may be considered. And one is a rule that there should be no repetitive question. And you've all seen it, where an advocate at trial comes back to a subject that he has asked about perhaps moments ago, perhaps 10 minutes ago, in the hope that there will be a different answer given. Now, we know that many judges will try and clamp down on that and say, that's already been answered, but often it gets let go. But it seems on my reading that psychological research, psychologists, have produced peer-reviewed papers saying that with vulnerable witnesses, repetitive questioning can put an extra degree of pressure on that witness to try to please the authority figures in court. And so there's a ban put on that. Open questions. So rather than, did you see, you saw the red car, didn't you? It might be more, did you see any car? What was the color of that car? But it's a less direct, immediate and pressured form of question. So arguably disadvantaging one of the parties. Ed's mentioned tag questions. I think we need to just remind ourselves what a tag question is, because many advocates, including myself, use them extensively. I suspect in some ways the list of question formats that you're supposed to steer away from are actually sometimes the most effective ones. So maybe a good piece of revision for cases which involve non-vulnerable witnesses. And a tag question is a statement with a form of words like, didn't you, or isn't it at the end. So you liked going into the shed, didn't you? And that form of question that many of you might think of as entirely innocuous, and exactly the sort of question that you see being asked in court all the time, is in fact a type which is strongly disapproved of by those who have written the documents that we've earlier referred to. And your questioning might have to be much more skillfully articulated. For example, did you ever go into the shed? Did you like it? Did you like going there? What happened there? You may have a direction about pauses being required between questions and controlling the pace of the questioning in court. Because we've all seen witnesses, whether vulnerable or not, almost being harassed by way of that. As soon as they've given one answer, before they've got time to take a breath, the next one follows, hoping maybe to put the witness out of stride, but of course paradoxically hurting the position because the judge doesn't have opportunity to note the answer down properly. So allowing adequate response time, tone of questioning, rudeness and sarcasm are frequently deployed, sometimes I have to say extremely effectively, in the right case, perhaps where a judge is a little unsympathetic to a witness or the answer he's receiving. So in that sort of situation, you might want a guideline that the tone of questioning has to be rigorously neutral. Another point is signposting of questioning. Now, this is very important. It's simple to do. And again, I could see a lot of emphasis being placed upon it. And indeed, if you're the one doing the cross-examination, you might want to put this forward as a sufficient safeguard. It's where you don't jump about from subject to subject to subject. And I was taught by another practitioner in Manchester early on, well, this is jumping around from subject to subject, taking them off onto side roads unexpectedly is very effective because the witness doesn't know where he's going. So insistence that a subject area is flagged up. I am now going to ask you about the subject matter of what happened in the shed. Then you ask a series of questions, and as soon as you wish to move off that topic, you've got to say that's what you're going to do. Chronological order and questions, not statements. Those are all techniques, and some of us might not even think that we engage in these forms of questions that might be unfair to certain witnesses, but also if you're the one wanting to put questions, you may want to keep these rules to a minimum and in a way which will prevent unhelpful interventions from one's opponent and indeed the judge. So I hope that answers a very helpful and important question.
There seems to be a note on the Q&A. Do you want me to go up and read it?
Yeah, sure.
Just whilst Isabel is checking the IT to see whether there are any other questions being raised, the point that Brian has just made was one that I experienced last year when I was required to cross-examine a witness who had been very ill served by her representative. She was in fact one of the people who were fortunate enough to have survived the Manchester Arena bomb attack, but was very significantly injured as a result. And the way in which her representative had advanced her case was to suggest that the harassment of her employer started on the night of the attack in a phone call that had been made by the victim while she was on the scene and the emergency services were actually caring for her. And the majority of her symptoms were in fact recovered in terms of physiological recovery, but she was still suffering massively from the sequelae of PTSD. And we had to tread very, very carefully, not only in the manner of the questions, but as Brian has mentioned, giving those pauses so that somebody who was clinically informed and sitting in the tribunal was able to gauge the level of her emotional and psychological reaction to having to reconsider and recall to mind some of those events. Because it's important to bear in mind that no matter what jurisdiction you're in, whether it's a court or a tribunal, it is no part of the tribunal's function or the court's function to conduct its own homemade assessment or diagnostic of whether that person is fit to give evidence in that moment, or is in fact operating under any difficulty. It's also helpful, perhaps as part of that preparation, to have the court made aware of any medication that the witness is in receipt of, and the frequency with which that is taken, and the potential side effects. And this is all about ensuring that we're all vigilant and informed supporters of whatever regimes that have been identified. So, Isabel.
If somebody else has asked a question.
So I think everyone can see that on the screen. It's whether it changes with the press being present.
Right, well, clearly, this is an issue that arises a good deal in regulatory proceedings. And one of the things we haven't touched upon, because we're conscious we're speaking to a group of practitioners, is that there will be occasions where, in fact, the vulnerability is very much vested in the witness. And the risk of that vulnerability being exacerbated comes from the fact that the opposing party in the litigation is a litigant in person, is not legally represented. And one of the measures in those circumstances is to ensure that either the court or tribunal takes over ownership of the questioning of the witness following ground rules, or alternatively, that somebody is appointed for that purpose to conduct that cross-examination. But in that context, it's quite common for mechanisms and adjustments to be made for the witness to give evidence by remote means. Now, there are obviously Article 6 points, and of course, we know from the authorities that the press have a right to apply to have orders on, for instance, restricting reported orders or contempt of court orders. There are circumstances where the press can intervene and make applications to the court for those to be varied. Clearly, in a case involving a serious sexual offence, just drawing upon the criminal jurisdiction, there will be lifelong anonymity, and that, of course, is triggered where a person says, I am the victim of a sexual offence. And in those circumstances, other mechanisms can include a restriction of that part of the proceedings. It might involve holding part of the proceedings in private, but the authorities are very much in favour and very heavily leaning towards the notion of open and transparent justice. So there would need to be a pressing reason why the hearing should be in private, but it may well be the court or tribunal is persuaded to exercise their case management powers to restrict the reporting of that part of the evidence. Does that try with your experience?
Yeah, I suspect that there will not be cases because of the vulnerability of a witness where the press will be excluded from seeing and reporting. You either meet the statutory criteria for a restricted reporting order, or there will still be open justice, but the press may, for example, have to sit in another room and follow by video link. And so there, I'm afraid, it probably is one of the stock answers of the video link being the only realistic solution. Mere vulnerability of a witness can't prevent open justice, which is a concept the court set such store by.
Just recalling a few years ago, some of you may have had involvement with antisocial behaviour orders being made in a perhaps more proactive way, where they're known as anti-gang injunctions, and it required a public authority to make an application to the court restricting, in effect, as a restraining injunction, restricting a particular individual from living in a particular place or associating with individuals for fear that they might be adopted or absorbed into a culture which is criminal in nature. And certainly about 5, 6, 7 years ago, these applications were becoming quite heavily relied upon as means of protecting the welfare of those who might otherwise be considered vulnerable. And in those settings, the courts made orders under, I think it was Section 11 of the Contempt of Court Act, which precluded the publication of any image or any other details which might reveal the identity of that person. But I agree with what Brian has said, save and except in those cases which involve the assertion that the witness is the victim of a sexual offence. Total anonymity is likely to be difficult, and certainly exclusion for the press likewise.
Could I just come back onto that point from talking about the criteria in the CPR before? It requires you to identify specific ways in which the evidence will be limited or proceedings would be limited. So you would come back to that test and there would have to be an assessment of how that was limited. And it would likely be that, as Ed says, for only part of the hearing. So if it was already an issue, somebody giving evidence in public, or as Ed has mentioned, in front of a lot of other people, there may be restrictions for those reasons, but it likely wouldn't be just because it was the press. It would have to be for a reason, for example, because it was a lot of people, but that's how you would go about it, is through looking at those particular circumstances. And it doesn't appear there would be a blanket rule.
Right, I don't see any more questions.
Well, thank you. I hope you found the presentation helpful. Thank you very much for logging in or for watching it in the comfort of your own home in due course. We've certainly found it helpful to us in acquainting ourselves with not just these principles and ideas insofar as they relate to our own areas of practice, but seeing, as Brian suggested, how these principles, these ideas and accommodations are in fact migrating from different jurisdictions and are likely to be here to stay. So thank you very much indeed.
Thank you very much.